The legal maxim Res Ipsa Loquitur is a Latin phrase meaning the thing speaks for itself. In tort law, it implies that in certain cases, the circumstances surrounding an injury or accident inherently suggest negligence on the part of the defendant without needing direct evidence. Essentially, it shifts the burden of proof to the defendant to show that they were not negligent. For a court to apply Res Ipsa Loquitur, three conditions are typically required. The accident must be of a kind that does not ordinarily happen without negligence. The instrumentality or agent causing the injury was under the exclusive control of the defendant. The plaintiff did not contribute to the cause of the injury. Municipal Corporation of Delhi versus Subhagwanti, 1966. Facts. In this case, a clock tower in Chandni Chowk, Delhi collapsed, killing several people. The tower was under the control of the Municipal Corporation of Delhi, and it was found that such towers typically last longer than the one that collapsed. Application of Res Ipsa Loquitur. The Supreme Court applied Res Ipsa Loquitur, holding that the collapse of a well-maintained clock tower would not occur without negligence. Since the tower was under exclusive control of the Municipal Corporation, the court inferred negligence. Conclusion. The Municipal Corporation was held liable as they could not provide sufficient evidence to show they were not negligent. Shyam Sunder versus State of Rajasthan, 1974. Facts. This case involved the collapse of a bridge in Rajasthan, leading to the death of passengers on a bus. The bus was lawfully using the bridge when it suddenly gave way. Application of Res Ipsa Loquitur. The Supreme Court held that a bridge collapse is not something that ordinarily happens if reasonable care and maintenance are exercised. The bridge was under the control of the state government, and the court inferred negligence under the doctrine of Res Ipsa Loquitur. Conclusion. The state of Rajasthan was held liable for failing to prevent the collapse due to lack of maintenance. Ratlam Municipality versus Vardhichand, 1980. In this case, residents of a locality in Ratlam filed a case against the municipality due to open drains and the accumulation of garbage, leading to unsanitary conditions. The municipality argued they lacked funds for proper maintenance. The court held that such unsanitary conditions would not exist if the municipality had exercised proper care in maintaining sanitation. The court inferred negligence on the municipality's part without needing direct evidence of each act of negligence. The Supreme Court ordered the municipality to take immediate steps to address the sanitation issues, holding them liable for negligence. K. Sobha versus Kerala State Electricity Board, KSAB, 1993. In this case, a person was electrocuted due to a live electric wire falling on the road. The Kerala State Electricity Board, KSAB, was responsible for maintaining the electric wires. The court noted that an electric wire does not fall and expose the public to such risk unless there is negligence in its maintenance. The KCB had exclusive control over the wires and was presumed negligent under the doctrine. The Kerala High Court held KSCB liable. The court used this doctrine Res Ipsa Loquitur as they could not prove they had exercised reasonable care. Pushpabai Purshottam Udeshi versus Ranjit Gaining and Pressing Kabya, 1977. In this case, the driver of a car owned by the defendant company was involved in an accident leading to the death of the plaintiff's family member. The accident occurred while the driver was transporting goods for the company. The Supreme Court applied the doctrine as accidents do not generally happen without negligence on the part of the driver. Given that the driver was under the employment and control of the company, the court inferred negligence. The defendant company was held liable for the driver's negligent actions, which were presumed to be within the scope of his employment. The doctrine of Res Ipsa Loquitur is frequently applied in cases where the circumstances of the incident imply negligence and the defendant has control over the situation. These cases illustrate situations where direct evidence of negligence may not be available, yet the nature of the accident implies negligence, shifting the onus onto the defendant to disprove it. This doctrine serves as a powerful tool for plaintiffs in cases where negligence is likely but challenging to prove directly. For in-depth insights and expert analysis on landmark cases and legal principles like these, don't forget to join the Kanoonplus live channel, your trusted resource for understanding the complexities of Indian law.